So, next, it is a remedial provision, so now we need to look at whether or not there is a regulatory scheme that's valid, and they decide that yes, there is. They identify the activities that need to be prohibited, they establish an investigatory mechanism, and they provide extensive redress options. So it's a complex and well-integrated scheme of economic regulation to reduce anti-competitive behavior. So are the intruding sections of the Act, are they valid? Are they functional and relational? Because the provision must be sufficiently related in order to be constitutionally justified. And they decide that they are clearly functionally related and would pass a stricter necessarily incidental test. And that's exactly what we're doing here, is the necessarily incidental test. So why would they pass it? And it's because they provide private remedies only for particular violations of the Act. They do not create a general right of action at large. Thus, it is fully integrated in the Act and really provides another arsenal in order to achieve remedies which discourage anti-competitive behavior. So this is a perfect example of a federal act which in pith and substance is from federal jurisdiction. However, there are aspects of the Act which affect the provincial jurisdiction, and through the test they are determined to be necessarily incidental and thus constitutional. It's worth noting, though, that they don't consider if these objectives could be achieved through other means, if there is a best way to achieve these means that don't perhaps infringe on or intrude on the provincial jurisdiction. They only look at it in terms of they only look at it within the scope of the Act. So it's kind of similar to looking at the better right versus the best right. They do not imagine a better circumstance. They simply decide whether the intrusion is constitutional, and if there is one, first of all. Another case that deals with this is the goods and services tax and the creation of the goods and services tax. And does this federal tax infringe on the property and civil right jurisdictions of the province again? So the idea here is that when you purchase a good or service, you pay GST. To the extent that you use the good or service in the production of other taxable supplies, you will receive an input tax credit. And so as the product increases in value, you receive credit for improving the value of that product. But once the taxable product is consumed, the purchaser cannot recover the tax. And so the GST is collected and refunded down through each stage of the production process. Now, if if the product has a GST exemption, the consumer pays zero tax and the final supplier still receives the GST tax credit. So the question is this ultra vires? Now, of course, the feds have authority to raise money by taxation, but this is having an impact, this is having an effect on the property and civil rights of the province, and is intruding on their jurisdiction. So we do the test. The preliminary questions: are the feds head of power? Are they the head of power to enact taxation legislation? Yes, they are. And in pith and substance, the dominant purpose of the Act is to raise revenues for the feds. That's fine. Does it intrude, and to what extent? It does intrude, but according to Laforêt, that doesn't matter, because in pith and substance, it is for the feds to create this tax. So these next few questions of deciding whether or not it's necessarily incidental don't even matter to Laforêt. But nevertheless, is the regulatory scheme valid? Yes, it is. And if valid, should the intrusion be permitted by virtue of its function and ration? And they decide that yes, to remove the revenue-raising aspect of the GST would change it from a value-added tax to a federal retail sales act. And so they decide that in Pith and Substance, it's a federal matter, and the intrusion is necessary for the function of this act, which is, again, in Pith and Substance, federal jurisdiction. So we reach the end of chapter 3 here. We've been discussing the meaning and validity of legislation, so how to interpret the legislation, and then looking at the Pith and Substance and the idea of necessarily incidental and functionally related in order to determine whether the legislation is constitutionally valid. Next, we're going to be exploring the applicability and the operability of legislation and wading into kind of more complex territory of interpretation and whether laws can apply or be operable. So it's decided that judges need to exercise restraint and strike down laws only when they are clearly inconsistent with the Constitution Act. And so there's a presumption of constitutionality when a law is created. So unless the inconsistency is clear, the judges need to exercise restraint. And this, of course, leads to the intrusions that are necessarily incidental and functionally related, and as we will see, intrusions that are in Pith and Substance intrusions. So we start by looking at the Canadian Western Bank, page 156, and labor conventions. I'm going to come back to this later, but we're discussing progressive interpretation versus originalist interpretation. I'm going to skip over that for now. Let's move on to the double aspect doctrine. This is kind of one of the main points of the chapter. So on the bottom of the screen here, subjects within which one aspect and for one purpose fall within section 92B, for another aspect and purpose fall within 91. And when we mean aspect and purpose, we mean Pith and Substance. So I like this description a little better. When the court considers that the federal and provincial features of the challenge rule are roughly equivalent in importance, so that neither should be ignored respecting the division of legislative powers, the decision is made that the challenge rule could be enacted by either the federal parliament or the provincial legislature. So if there's a challenge rule that is equivalently important to a rule in the other jurisdiction, then they, either of them, either the federal or the provincial government could enact that legislation, which seems counter to the Constitution, but it doesn't apply in all circumstances. So we look at Hodge versus the Queen regarding the constitutionality of the Federal Temperance Act. The section 91(2) allows the federal government to create laws in trade and commerce. However, there is also a provincial liquor license act. So there's a conflict between the two here. But can the issue fall within more than one class of subjects? And they decided, or it was decided, and this is what created the double aspect doctrine, that they could. So the intrusion of the provincial legislation with regards to the regulation of liquor was allowed. Now in this case, they cited the Parsons case, which is an important case because it held that subjects that for one purpose fall in section 92 may for another purpose fall in section 91. And this relates to the argument that insurance is commerce and is thus federal, and the provinces should not be able to regulate it. I don't know what that is. So, coming back here, the double aspect doctrine. I think we need to go on to the next case. So it was cited in order to say that the liquor control is a strictly federal matter. They cited Russell versus the Queen, where it was And now in this case, the convicted argued that the Canada Temperance Act could not be supported by the division of powers. So the federal government could not regulate prohibition and liquor. The decision, however, was that it is not exclusively provincial, that temperance is a common concern, and thus liquor is federal according to Hodge. So that was used in order to argue in Hodge versus the Queen that the Temperance Act and the following Russell versus the Queen case made the regulation of alcohol strictly a federal matter. And in this case, the Provincial Liquor License Act should be unconstitutional. However, due to the double aspect doctrine, laws for one purpose may fall within the federal jurisdiction and for another purpose may fall within the provincial jurisdiction. So it's decided that both of these acts were constitutional. Multiple access limited, another example of the double aspect doctrine. So there are sections of the Federal Canada Corporations Act which prevent insider trading, and there are also sections of the Provincial Securities Act which prevent insider trading. Now, are either of these ultra vires? And if not, does the doctrine of paramountcy cause the Provincial Securities Act to be inoperative? So the decision was that the Corporation Act was intra vires, and this wasn't contested, even though it does contain a civil liability element. And it was decided that the Securities Act is inter vires as well, so they have the power to regulate the trade and commerce of securities within the province. And federal incorporation, like if you're a federally incorporated company, you are not immune to these laws. So the decision continues. They're both intra vires. And it was decided that paramountcy here is needless because they are roughly equal importance, which is exactly what the professor states the double aspect doctrine is. Not only are they roughly equal importance, they're almost identical. And so there's little reason to kill one to let the other live. So for one purpose, the regulation of corporations within the Dominion, for that purpose you can regulate insider trading. And then for a provincial purpose, the regulation of trade and commerce within the province, regulating securities trading, they can also create legislation that restricts insider trading. So, and this argument arose because of the limitation period in the Corporations Act was different than the Securities Act, and the limitation period in the Corporations Act had expired, and so the only way that the plaintiff was going to, the only way that the case was taken to court is if the Securities Act was applicable. So, language of the law. Standing. Standing is the recognized position to bring a constitutional issue before the court. You gain standing if you are charged with a crime, or you can request standing through an action for declaration. Note on a constitutional reference, there are no parties, and also note that in the Union Colliery case, there was collusion in order to gain standing and bring this matter before the court. Matters and classes. Classes are the subheadings in 91-92, and matters are the issues associated with certain classes. Mutual modification is subtracting a specific power from the federal class of powers for the province. So the federal government has jurisdiction over marriage, but the provincial government has jurisdiction over the solemnization of marriage. Collocation, this is the placement of classes and matters in 91 and 92. So the criminal law and the regulation of banks are co-located in section 91. Double aspect doctrine, we already gone through this. Pith and substance is the principal and dominant purpose of an act or legislation. Incidental effects are effects outside of pith and substance of the legislation, and these may intrude on other heads of power. Necessarily incidental, we went through the test for this, but if the intruding effects are upheld by virtue of their ration or function or within the regulatory scheme, which is valid, then you're going to have a constitutional intrusion. Not to mention the double aspect constitutional intrusion. Colorable, describing that which is one thing in appearance but another in substance. So a statute may appear to be one way, but in substance is actually doing something else. Trenchy is an old-fashioned term for jurisdictional intrusion. Paramountcy in terms of the Union, if there is an inconsistency between provincial and federal legislation, then the federal law supersedes. However, it's still valid, it's just inoperable. That's an important point. Conflict, operational inconsistencies between federal and provincial acts are known as conflicts. Occupying the field, I believe, is when one jurisdiction acts to create legislation in a field which may be for the other jurisdiction, but perhaps there's no legislation there yet. Great.